rise. Federal Code Division 1 is now.
Good morning. Please be seated. This is the time and date set for oral argument in BLK Free LLC versus Luke Skelton et al. These proceedings are being video and audio recorded as well as live streamed. So we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs. We've discussed this case in conference. We're familiar with the facts. Please keep that in consideration during your presentation. At this point, Mr. Horner, are you ready?
Yes, Your Honor.
Please proceed.
Thank you. Madam Chief Judge, may it please the court. In the answering brief, am I okay on the mic?
You can raise it up just a little bit, Mr. Horner.
I'm just hearing an echo. That was my only concern. And the court has been given copies of the statute. Do you have that in front of you?
Yes.
Yes, thank you. In the answering brief at page 21, defendant states, first, nothing in the plain language of the statute supports BLK's argument that ARS section 12-751 is a precondition to even reaching ARS section 12-752. This statement is a puzzle to me. 752A, which is the very top of the first page, begins as follows. In any legal action that involves a party's exercise of the right of petition, defending party may file a motion to dismiss under this section. So 752, which is the substantive section, does not apply unless the action involves a right of petition. That is defined in section 751. If your honors will look at page 2, 751 is the definition section, and that defines what involves a right of petition. And it is defined as falling within the constitutional protection of free speech. So if the statement does not fall within the constitutional protection of free speech, 752 does not apply. It's that clear. And so I'm puzzled as to how the other side can say that it's not clear that 751 is a precondition to 752 by its own language. It clearly is. At page 4 of our reply, we cited 3 U.S. Supreme Court cases holding that defamation is devoid of constitutional protection. Defamation is our claim. Defamation is not constitutionally protected.
Mr. Horn, let me ask you specifically so that we can really focus in. What is the defamatory statement that is the basis for your defamation action?
The defamatory statements are that the noise from BLK was horrendous, horrible, I couldn't hear myself think, made at a time when, at a minimum, 50 tests showed that the level was 50 decibels, which is 1/4 of Scottsdale's line for between reasonable and unreasonable sound. And at a maximum, we have a number of cases where there was no show at all. What happened was that the neighbors made a calendar where they would, as to when they would call to make complaints, and they didn't bother to check it against the show calendar. So at times when there was no show at all, neighbors were saying, the sound is so loud I can't hear myself think, it's invading my house, it's greater than my television set, and there was no sound at all. These were the defamatory statements, Your Honor.
So there, where is it in the record that calls occurred at the times when the business had or did not have?
It's in the declarations, which are in the appendix to our brief. If you look at the declarations, they specifically say that the police showed up indicating that complaints had been made to them, and they showed up and there was no show.
Counsel, do I understand correctly that in response to Judge Campbell's question that the defamatory statements are noise complaints that you claim are inaccurate?
Yes, and more than inaccurate, they're outright lies. They're not. It's not a matter of opinion. They're facts.
What's the best case or support you have for the thought that an inaccurate noise complaint is defamatory?
The police showing up to BLK saying they've got complaints from neighbors and there's no show going on.
No, and what I'm talking about is legal authority, legal case, saying that an inaccurate noise complaint is defamatory.
Well, the legal cases I don't think are that specific as to, but the legal cases say a lie is defamation. If it injures you, which this obviously did, it put us out of business.
And
So-
Mr. Horn, you stated that it isn't an opinion. Would you agree with me that there are differing levels of noise that will irritate a person based on the person's general character?
I agree with you, Your Honor. However, there are factual claims here that are susceptible of proof as to whether they're true or not. I refer the court to page 5 of the response brief, where one of the plaintiffs says he heard music from BLK Live over the sound and music of the television. That's not an opinion, that's a fact. It either could be heard over the sound of the television, or it could not. Another one said it could be heard in his home over his television, and he not only heard the music, but could understand the lyrics. That's a fact, that either it was loud enough for him to hear the lyrics, or it was not.
And when we talk about loud enough to hear the lyrics, there was a complaint that went to a non-emergency police number. The police responded. You were saying when the police responded was when the activity was occurring?
When the police responded, there was no,
I hear what you're saying.
Yes, Your Honor.
If it's a non-emergency number, how do we correlate when the call went to the police and when the police responded?
it's a night where there's no show scheduled. So whether they responded within 15 minutes or an hour or 2 hours, it wouldn't make any difference. I think those also are facts that a jury should determine rather than a motion to dismiss based on an assumption that, maybe it occurred, the next day or something like that. Those really should be jury questions rather than a motion to dismiss. I think if I could, I'll reserve the rest of my time for reply.
Thank you, Mr.
Thank you, Your Honor.
Counsel, when you're ready.
May it please the court. Good morning, Your Honors. My name is Ryan Sandstrom. I'm with the law firm of Sanders and Parks. I represent Amy and Michael Satterfield, who are in the collective group of defendants homeowners that were sued by BLK. Just for purposes of the record, my client, Amy Satterfield, he is here in the court with a number of the defendants that have been sued. Your Honors, I'm going to try to address a couple of those questions that Mr. Horn brought up because I think I can answer them for the court. I will just note that the trial court got this one right. Anti-SLAPP, I think everybody's well aware of the purpose of anti-SLAPP. It is quite literally to protect individuals from exactly what's going on right here. We have individuals that have issues in their neighborhood and they go to the police and they go to their local city council members. To be honest, it's pretty amazing how coordinated they were in doing that, to have meetings at their homes with council members present who instructed them to call the non-emergency line. So they're doing exactly what they're supposed to do as their civic responsibilities to discuss issues that they're having in their neighborhood. And what else are they supposed to do? Honestly, honest question, what else are they supposed to do in this situation other than ask for some redress from their local officials? So Arizona passed the anti-SLAPP statute specifically to protect individuals from this type of harassment. If the court allows BLK to just overcome this motion to dismiss and move forward with fact discovery, that defeats the purpose of anti-SLAPP. The whole purpose is to create a judicial mechanism. It's not a standard Rule 12 motion to dismiss. It's a special motion that allows the court to get rid of these cases very, very quickly, within 90 days of filing the complaint. The purpose of that is to not have to subject homeowners like this or individuals to claims that their statements are defamatory or ridiculous or harmful, when in fact they're made for the purpose of affecting change to their local leaders. So again, if this court were to allow this case to move forward, it literally defeats the purpose of having the statute in place. So back to my original point of the 12B6 motion. This is not a standard Rule 12B6 motion. Mr. Horner, in his opening brief, the very first thing that he cites is Colon v. Auto Owners, which is your standard Rule 12B6 motion that understands and applies questions of, the court in that case specifically looks at whether or not the facts have to be assumed in favor of the non-moving party. Obviously, that's not the case. If that were the case, Again, in a defamation case, all plaintiff would need to do was allege anything, and now it's overcome the statute, and again, there'd be no purpose to anti-SLAPP statutes. So again, this is not a standard Rule 12 motion. The specific protocol or procedure for evaluating this statute is this type of motion to dismiss is expressly stated in the statute. It's very clear. First and foremost, let's look at the language of ARS 12752, and I'm going to address Mr. Horn's question here directly about the combination or the use of 12752 with 12751. 12752, and I agree with Mr. Horn, he says, and I'll read the language, in any legal action that involves a party's exercise of the right of petition. So we agree that we do have to establish the elements of 751 which discuss what the right of petition means. The question just is, what facts can the court consider in making that determination? So Mr. Horn would suggest that the court only have to consider the pleadings, but then at the same time he says, well, the basis for our defamatory statements is the declarations that are submitted as part of this whole record. Doesn't make sense. So the point is, the court is allowed to consider the pleadings and then act as a gatekeeper in looking at all of the information that's been submitted in the case, understanding, looking at the statements, if there are any, we'll get to that, looking at the statements, looking at the facts, and using its gatekeeping function to look at the pleadings and make that determination of whether or not they could have defamatory meaning. So the point is, actually this is a really important point too. Mr. Horn repeatedly in the initial brief and the reply focused on a case called True North Companies, which is an unreported decision here from the Court of Appeals. What's interesting about that case is it stands exactly for the proposition that I'm saying right now, is that it's not just pleadings alone, but that the court needs to evaluate other facts that are included in the record, such as declarations or affidavits. First off, the court actually looks at it defines what defamation is, and then it goes through the elements of defamation, and then it goes through each individual statement line by line to determine whether those statements could have defamatory meaning. And there's 5 specific statements in there, and I'll just draw the court's attention to this case. For example, the second element, when the individual in there said he was shocked, well, the court then looked at the record. The court then looked at the entirety of the documentation submitted in that case to understand whether or not that could have defamatory meaning. The third statement in there said, well, we need to read this statement in context. Let's look at the evidence, right? Let's understand what this is doing. The fourth, and this is specifically what it says, in his declaration, the court denied that his business, ... The point being is the court evaluated the specific facts in understanding its gatekeeping function. So when the defense says that 12751 and 752 have to be read in conjunction, that's what we mean. And perhaps that clarifies for Mr. Horn. We're not saying that we don't have to establish that it's the right of petition. We acknowledge that we do. But we're just saying that in order to establish that right of petition, the court, using its gatekeeping function, has to understand and evaluate all the facts on the record, not just allegations that must be assumed in plaintiff's favor.
What deference, counsel, is owed to those findings? I get that this is a 12B, but it's different. And that's because of the anti-SLAPP statute. But it also strikes me it's a little different than a 56, too, than a motion for summary judgment. But it's not really a bench trial. So where are we in the continuum of deference that is owed to the trial court?
So I believe questions like this of constitutionality of the underlying speech actually is, I have it written here, in terms of the legal standard. I want to cite the correct case for it. It's for abuse of discretion. And that's because there's underlying facts that have been determined by the trial court. So again, it's not solely a question of law, it's a hybrid, it's a question of law and facts. So I appreciate your it's not a 12B6, it's also not a Rule 56. It's a specific special motion that allows us to move to dismiss after considering all those facts. Now, Mr. Horn actually cited to a California case. California's anti-SLAPPs are much broader than Arizona. And in there, the plaintiff had to prove a probability. Again, that's based on the specific statutory language in that statute, that the plaintiff has to prove a probability to strike the complaint. They use strike instead of move to dismiss in California. So, I mean, At the worst, Your Honor, it's at least a probability, and I look at a probability as more likely than not. I mean, it's probable that the end finding is what it is, right? So I think it has to be that fact finding initially. But on the continuum, I agree, it does fall somewhere in between that 12B and Rule 56. All right.
But one of the facts, at least, been presented in this case, seemed to help, is that the neighborhood residents were trying to impact the conditional use permit that the business was trying to get as a use permit or to convince the city to revoke it.
Yeah, I don't disagree with that, Your Honor.
So this wasn't just merely calling and saying, you've got a loud neighbor. This is, you've got a loud neighbor and there's something that we can do about it. You can do about it, council member. You can do something about it, city council, because of at least how we perceive that it affects our peace.
Yeah, very much so. And again, it actually goes to one of the causation elements that we'll talk about. But I agree with Your Honor that the point of calling the non-emergency line or meeting with city council members was to affect change, was to have some difference in their home so we're not hearing music all throughout the night. But at the same time, I agree with Your Honor that they were making those calls for the purpose of that conditional use permit. That's one of the conditions that has to be met. It has to be something that's under review by the public officials at the time when the statements are made. So it's a conditional use permit. It's not a permanent use permit, right? So it was conditional. The city council members that met with the homeowners told the homeowners, hey, this is up for review, so you guys need to submit any questions or issues you have. Now, and we'll get to this, but as to causation, those statements alone actually are not the reason that BLK was shut down. BLK was not shut down ever. City of Scottsdale did not issue an order, cease and desist, or anything to prevent BLK from operating other than the size of its stage and the location of its trusses. So there is not a single piece of evidence in the record that these noise complaints directly, causationally caused that use permit to have issues at all. Now, I admit at the same time that the purpose of the homeowner's actions were to potentially influence that, but that's not the end result. The end result is BLK chose to shut down. They got 2 notices from the city that said, hey, your stage is too big. Hey, your trusses are in the wrong location. Your conditional use permit is unambiguous. Change it. And here's a fine. And you know what BLK did? Instead of changing it, they just went away. They decided to close up shop. So in terms of causation, yes, we were attempting to have some impact, but the ultimate outcome was not based on what our homeowners were attempting to do. All right, Mr. Horn talked about defamation. I appreciate Your Honor's questions. That's been the question that I've had since the entirety of this case. What are the defamatory statements? Defamation is not a scheme. Defamation is a statement. What other statements? I honestly want to know. Mr. Horn said, oh, there's a couple of these statements in the affidavits. What? I hear music? Okay, is that defamation? I hear noise in my house. Is that defamation? And Mr. Horn says, well, there's a conspiracy, this grand conspiracy. Well, to Your Honor's point, the homeowners are calling a non-emergency line, right? They don't know if they're hearing music that's being played behind their house, or they don't know where that's emanating from. They say, hey, we're hearing something. Maybe it's a crowd, maybe it's music, maybe it's something we're going to call. And then maybe by the time the police show up after calling on the non-emergency line, I don't know about Your Honors, but I've ever called that line. It takes a long time for people to respond. So the point being, yeah, there's really no statement in the record that ever could be defamatory. Now, then the next logical end goes to, well, what if there were some statements in there? Well, the court then still gets to use its gatekeeping function to determine whether or not those statements could be defamatory. I mean, as of right now, there are none. There are no statements that are defamation whatsoever. So whether the court looks at it on a prima facie case, right, interpreting just what's been pled, as it's been pled, there's been no defamation. So even assuming Mr. Horn's, desire to assume their facts in their favor, assume that for a moment. There's still no defamation, right? But now looking at all the facts in conjunction with each other, now we understand that there is no statement that's been made that could be defamatory in the slightest.
In preparing and thinking about that, have you thought of what sort of statement from a residential homeowner in the neighborhood could be defamatory with respect to the sound?
With respect to the sound,
I can think of lots of ones that could be defamatory, okay? But at least with respect to the sound.
I think to a logical end, I'm not quite sure. I'd have to see the statement, and honestly, that would have to be something that we'd have to look at. But if they said that my daughter's dying because I'm hearing sound in my house and it's killing her or something like that, then maybe. I mean, you know, if it goes to an extreme end where they're saying, hey, this is really, really bad, you have to send police over there right now, this is a terrible situation, you know, they have 1,000 people and they're doing drugs and all, I don't know, we could go to some incredible degree. And then you could run over there and the police raid a party and say, well, actually there's nothing going on, no big deal, so maybe there could be harm.
Can the logical consequence of that be that the caller would be charged with false report?
100%, 100%. Yeah, so that's actually an interesting discussion. Mr. Horn suggests that this goes to a different case. These statements, and I need to back this up a little bit, the statements that are made, first off, to police are 100% entirely subject to absolute privilege, right? They cannot even get into the motives or anything like that because they're absolutely privileged. So looking at Mr. Horn cites to this Selby v. Savard case, which was a 1982 Supreme Court case. We've cited to Ledvina, and he says, hey, you know, in order to overcome this, in order to overcome these statements, the court has to overturn a 15-year-old Court of Appeals case as to privilege with regard to reporting to police. That's his position. And he says, well, if we don't overturn that, people are never going to, you know, if they report stuff to the police, there's no consequence. Well, to Your Honor's point, there absolutely is a consequence. The court in Ledvina, what's really interesting is in Ledvina, the court actually interpreted that Selby case, which Mr. Horn would have us apply, and distinguished it on its face, right? So Selby, that case involved a public figure, so defamation aspects are different when you talk about a public figure. You actually have to have actual malice, right? So the court, of course, had to look at the motives in that case to understand whether or not those motives fit actual malice. Couldn't be absolute immunity. But when you're making a report to police about some issue that's going on, about a potential criminal activity, you don't want to tell any individual, don't call or else you're going to face civil liability. I mean, if they're wrong, if there's nothing going on at that location, they file a false report. Ledvina says this very, very directly in the last paragraph of that particular case. They said if there was something that was not going on, it was a lie, that's a criminal citation. But the case specifically said anybody who makes a statement to police is immune from civil liability. That's what we have here. This is not a criminal case, obviously. I have a lot to cover in 4 minutes, so I will point to the court. I think this is fairly well briefed. I think that we do have some the court has a responsibility to make that gatekeeping function, that there is no defamatory statement that's been made. And then once we establish that it's the right that speech is there, then we look at the definition of right of petition. So briefly, I'll go through those elements with the court. And then I'll wrap up. So first, it has to be submitted before. We are not claiming this is an initiative, referendum, or recall, by the way, so that's not at issue. Obviously, then we do have to prove those three elements of 12751. So it's made before or submitted to a legislature or executive body. So nothing in there requires that it be the entirety of the legislative body sitting in session. Right? It's submitted to an executive or legislative body, and then go figure, or any other governmental proceeding. So governmental proceeding actually includes an officer or individual. Right? So Mr. Horn's position is, well, it's not a body, they're not sitting in session, so it can't be protected. Well, then it goes on to define what the purpose of this statute is. It means an officer, official, or body. So if statements are made to an individual officer, and then those are submitted to a body, this was submitted to the city of Scottsdale, right? Because of these homeowners. So it was. The question is whether that initial statement made to those council members was also submitted to a body. It was made to an individual that was eventually submitted to a body. So our point is that element has been met. Made in connection with an issue that's under consideration, obviously, as we talked about with Judge Portley, that is the case. This is something that was under consideration, being a conditional use permit. And then this last point made for purposes of influencing governmental action, that's not in dispute. I think we all recognize why the homeowners are making these statements. So 751 has been established, and then, again, through the court's gatekeeping function on that scale. And then once we get to 752, the burden is very, very clear. The court shall grant, mandatorily shall grant, unless the party against whom the motion is made shows that the moving party's exercise of the right of petition did not contain any reasonable factual support or arguable basis in law, and that the moving party's acts caused the actual compensable injury. So if once we establish that defamation has not occurred, once the court exercises that gatekeeping function, once we establish these three prongs of 7511, we then get to this question, are there any facts in the record that suggest what the homeowners were doing was reasonable under the law and factually? Remember, there's 250 people that signed a change.org petition. There's a number of homeowners that don't even know each other, that decided to come together and say, we're having issues. And that alone is a fact. Right, it's a arguable basis in law and in fact as to why that we're doing. If that's the case, the discussion over. We're done. It's free speech. We establish the prongs in 751. If there's any basis, which we have, I mean, there's a lot of basis for it, to be honest. But I mean, more likely than not, even in our favor. But plaintiff will never be able to meet that burden. Now they're going to come and say, well, hold on a second. There were sound readings. We didn't see those. That's an argument of fact. That's not what they get to argue right now. Is if there's any reasonable basis at all for the homeowners, they win. And that fits perfectly with the statutory framework. If that wasn't the case, we would have these lawsuits all the time. Homeowners would be subjected to this type of litigation. They would overcome a motion to dismiss. Now they're being subjected to depositions. Who knows what kind of issues, if these people are paying individually, whether they have insurance. I don't even know all that stuff. The point being is they're being subjected to litigations for speaking out about problems that they're having in their neighborhood, and that can't be allowed. I believe we've met all the elements of 751. I believe that plaintiff can never establish the elements of 752 because there is an arguable basis in fact in law. And then the last point, I know I'm out of time. The last point is just what I said before. There is no causation here either. Trial court got this dead right. There are no statements that caused BLK to shut down. BLK shut down because it chose to. Thank you, Your Honor.
Thank you, counsel. Mr. Horn.
Thank you, Your Honor. Actually, there may be more agreement between my friend on the other side and myself than one might expect. He said you look not just to the complaint, but also to the surrounding facts. And I agree with that 100%. And that is why we submitted declarations under oath and established under oath that the neighbors complained about deafening noise when 50 tests showed that it was 1/4 the level of what Scottsdale considered unreasonable noise and was no more than the sound of a car going by. Our declarations established that complaints were made to police and the police showed up and there was no show at all. And people were saying things that are factual, that they could hear the lyrics. So when counsel says, well, maybe they heard a neighbor and they made a mistake thinking it was my client, if they said they were hearing the lyrics, that seems very fanciful and certainly should be a jury question, and that kind of speculation should not be the basis to sustain a dismissal of the case without any facts being heard.
Counsel, let me ask you, facts were heard, though, here, right?
I'm sorry?
The trial court considered the factual information provided to it.
Yes, it did.
And what deference does this court owe to that consideration?
Yes, that was a question I wanted to address. Thank you, Your Honor. In the cases where this court says it defers to the trial court, it says explicitly it does that because the trial court hears the evidence and can judge the credibility of the witnesses. In this situation, there is no evidence heard by the trial court. The trial court looks at the same declarations that Your Honors look at. And therefore, it's my position that no deference is owed. It's a de novo consideration because there is absolutely no credibility determination made. The trial judge, I said in my brief, would have to be not only a genius, but who have extrasensory perception to look at two declarations and decide which is true and which is not true. All that's before the trial court is in writing, and this court has exactly the same as what the trial court has. Now, on the language of the statute, I'd like to refer the court to the statute again because I think my friend on the other side was mistaken in what he said. First of all four conditions in 751 have to be met. If one single condition is not met, then the case is not dismissed and we have a right to our trial. We've discussed at length condition number one, that we have a defamation allegation supported by testimony under oath, and the U.S. Supreme Court says that is not constitutionally protected speech. The second one is made before or submitted to a legislative or executive body or any other governmental proceeding. That is not satisfied here. A legislative or executive body is just that. It's a body. I served in the legislature. When I talked to my neighbors, that wasn't an official governmental proceeding. That was just me talking to my neighbors. An individual legislator or council member does not constitute a governmental body. They have no power as an individual. The only power rests in the body. So it has to be submitted to a legislative or executive body. Now, executive body could be a government official other than a legislator, if he has powers or she has powers that pertain to that individual. But a legislator or a city council member has zero power. They can only show up at a meeting, vote, and then the body acts. Or any other governmental procedure. An individual council member talking to their neighbors is not a governmental proceeding.
Can I stop you there? We look at A. It says, or submitted to. Does that mean submitted to only while the body's in session, or does that mean we can gather information and later submit it to the body?
If it's submitted, if it's a submission to the body, it's protected. So if they did, for example, a petition to the city council, and they submitted to someone, please present this at the city council meeting, that would be protected. But simply conversations between an individual council member and the neighbors is not, does not satisfy this section.
So if we go back to 1, and it says any written or oral statement.
Yes.
And then we go submitted to a legislative or executive body.
Mm-hmm.
Why would they have a conversation with a council person but for the influence on the entire body when making a decision?
Well, in this case, it wasn't submitted. In our declarations under oath, we said the question of noise was never considered or submitted to a city council meeting. This was solely between the neighbors and an individual council member, or between the neighbors and executive members.
But then we look at what was under consideration. If we go back to the use permit, they inherited a use permit from the previous tenant of the building, is that correct?
Yes.
And that use permit had to be renewed, is that correct?
Yes.
So wasn't part of that renewal determining noise levels?
No, Your Honor, the use permit has nothing to do with noise. The use permit pertains to things like the size of the stage, where things are located. But the only thing in the Scottsdale system that pertains to noise is the noise level, which is 4 times the maximum of all measurements made when there were 50 measurements using the same equipment that the Scottsdale police use. But there's nothing in the use permit pertaining to noise.
So the use permit does not contain ambient noise sound restrictions?
The use permit is, I'm sorry, Your Honor?
It does not contain a separate restriction for ambient noise?
That's correct.
Separate and above City of Scottsdale's ordinance regarding noise, is that what
Exactly,
you're saying?
that's exactly right, Your Honor. And that sets a decibel level, and there were 50 measurements, and not one of them was more than 1/4 of the Scottsdale City Ordinance on noise. So So this was not submitted. I mean, if the city council had scheduled a session on noise and they wrote a petition and they said, please bring this to the council meeting, that would have been protected, but that's not what happened. They had conversations with the legislator. The legislature made threats to them, to my client, said we're going to, shut you down. But there was never a question about a meeting of the city council to which this would be submitted. So Section A is not met. And remember, if they miss one, I mean, we could lose on 2 out of the 3 that we've challenged. If they miss one, they don't satisfy the statute. And council mentioned that California has a broader statute than we have. In this case, they have to meet this statute. So they have a lot of language in their briefs about aspirations and purposes and so on, but we have a specific Arizona statute. If they want to change the statute, they can go to the legislature, but before your honors, I think they're required to meet the language of the statute itself. And then the third one that we questioned was made in connection with an issue that is under consideration or reviewed by the legislative or executive body or any other governmental proceeding, and we have declarations under oath saying noise level was not under consideration. This was just conversations with individual members. But as a result of those conversations, people in the executive department of the city started telling us that we weren't going to get our use permit, and that put us out of business. And that's uncontroverted. That's uncontroverted in our declaration. They haven't submitted a declaration saying, no, it wasn't you being told that you're going to lose your use permit that caused you. They left it alone. So you've got an uncontroverted declaration saying the reason we stopped business is because we were told by city officials that we were not going to get our use permit.
So in all other ways, were your clients in compliance with the requirements for obtaining the use permit, but for the noise?
Well, the city has discretion. Yes, my client was in compliance, but the city could say, we told you could have a 50-foot stage, now you can only have a 10-foot stage. Or we told you you could put your loudspeakers in this place, but now we're going to have it in some totally impractical place. They have the ability to make it impossible for my client to operate. And so and here again, they may want to argue to a jury that we could have said, no, you may threaten us, but we'll go to the council and argue it. They could argue that to a jury, but before this court is an uncontroverted declaration that says, because the city official said you're not going to get your use permit, we gave up and closed down and we lost all our business.
Okay, but that presupposes that that claim, you're not going to get your city use permit, is premised solely on noise complaints. What I hear from opposing counsel is there were other issues that needed to be addressed by your client in addition to the noise complaint.
Well, that really should be a jury question, because we have under oath that is what caused it. That it was not a question. I mean, we have made a lot of adjustments. That's in the declarations also that are attached to our brief. We made a lot of adjustments on use permit, but it was because the officials told us that the complaints they got were going to cause them to make sure that we did not get a use permit, that we shut down. And I don't think that declaration can be ignored. It's not even controverted. And that sort of brings me to the question of what is the standard to meet? And I think the standard is set forth in a decision of this court, and that is the True North Arizona case, in which this court said the standard is that our burden is to make allegations of facts which, if true, prove the statement's falsity. If true, proves the statement's falsity. So that, whether or not it's true or not, has to be determined by a jury. You can't determine that just on complaint and some declarations. We've also cited the tougher standard, which came from federal courts dealing with Arizona cases, saying that we need to make a prima facie showing of facts to sustain a favorable judgment. That's in the complaint itself. if the evidence submitted by plaintiff is credited. We've submitted evidence under oath. The question is, if that's credited by the jury, then we've made our case. And so under this standard, by making all the legally sufficient allegations in the complaint, and then by presenting declarations, which if believed by the jury would establish our complaint, we've carried our burden to prevent it. And if I just one point on that is, we've also cited to the court Ninth Circuit cases that are directly on point because they deal with these kinds of statutes, and they are even more liberal than this standard. I've cited that in the brief.
And in a defamation case, this court and the lower court is asked to look at a specific statement to determine the truth or falsity thereof.
Yes.
We're going to go full circle. My first question
Yeah.
to you, what is the defamatory statement you're asking us to assess the truth or falsity of?
Okay, I'll give you, let's say, 6.
Okay.
1, noise is so loud, I can't stand it. It's quoted in their brief that, and it's never measured above 1/4 of Scottsdale standard, and sometimes it happens when there's nothing going on. I heard the music was heard over the sound of the music on the television. That's a factual statement that could be tested. It could be heard over the television. It could not only hear the music, but it could understand the lyrics. That is a factual question. If it is not possible that 1/4 of the Scottsdale sound is going to be so loud in somebody's house that they can understand it over the lyrics, that's a false statement. The MC could be heard shouting. I'm quoting these all from their own brief as to what they've said. They're factual statements, and if our declarations are accredited by the jury, they are false statements, and they are therefore defamation.
Thank you, Mr.
Thank you, Your
Martin.
Honor.
Well, thank you both for your arguments. Very interesting issue. We will take this matter under advisement, issue a written ruling in due course. At this point, we are adjourned.
Thank you, Your Honor.